Jon Roland at the June 18th, 2013 Constitution Meetup in Austin, Texas. The next topic is the disparate treatment by conservative activist groups by the IRS in the processing of their 501c4 applications. Now, I need to explain a little bit that there are two kinds of organizations, actually three kinds of organizations at play in this field. The first are 501c3s. That's organizations, donations to which are deductible. The second are 501c4s, to which donations are not deductible. And the third are 527s, which are political action organizations, including political parties. There are various statutes and rules and so forth applying to each of them, but there's also a lot of confusion about it. Now, a lot of people thought that they needed to file an application with the IRS to get a letter approving their 501c4 status. That is not correct. There is no legal requirement to do that. The way that the IRS got involved in this whole thing is actually not from a tax statute, but from a campaign finance statute, which provided that if most of the activity of a 501c4 was in support of a candidate for, or opposition to candidate for public office, that they could be taxable at the lowest prevailing corporate rate on one of two things: either the amount that they donated or the amount that they earned from investment income, whichever was less. Now, of course, most of these organizations have no investment income, therefore would not be liable for a tax. Now, the question arises then, suppose that they did have investment income that was substantial. Well, they could avoid having to pay a tax simply by disclosing their donors. If they don't want to disclose their donors, then they want to maintain their 501c4 status, under which they're required to disclose substantial donors to the IRS, but not to the public. Now, in fact, we have seen several cases where some of those lists of donors that were supposed to have been kept secret by the IRS found their way into the possession of competing activist organizations. So clearly the IRS cannot be trusted to maintain the privacy that they're supposed to maintain over the information they receive. But it's a simple matter to avoid the whole thing by creating an organization, not applying for a 501c4 status, can go through an entire election cycle, then just fold the organization, and there's nothing the government can do about it. So, if you want to entertain yourself, catch a few past episodes, which I think are online, of the Colbert Report, in which he invites on Trevor Potter, who is a leading election law lawyer, to explain all this. And it's very funny. Between Colbert and Potter, they can make the whole subject seem so ridiculous that you can't help but laugh. However, the question is, how is it that all these groups thought they had to apply for it and that they couldn't conduct their activity until they got the approval. Well, the answer is that it's all a hoax. There's no law. No law on a lot of subjects, including that you have to file and pay income tax. But naive organizers have been distracted and delayed in their efforts by deception, inducing them to do things that are not required. The result was the clever diffusing and suppression of activist groups at the height of their enthusiasm. This is the classic trick of tyranny. The solution is not equal treatment, but doing away with campaign finance statutes which only protect the corrupt.